Good afternoon to the Honourable Chair, Honourable Committee members. My name is Jack Devanarayan. I represent the South African Guild of Actors, or SAGA, in my capacity as Chairman. I'm privileged to submit SAGA's presentation today as a coalition partner of UASA, an affiliate of FIDUSA. SAGA is a powerful, unified voice for actors in the film, TV, stage, commercial and corporate sectors with a mandate to lobby support for the legal and economic rights of professional actors. Established in 2009, SAGA is a registered non-profit company and we are proud members of SASFED in South Africa and FIA internationally. To summarize, SAGA wishes to present a case in support of the Performance Protection Amendment Bill, the PPAB, and in support of earning rights for South African actors. We will present a case that demonstrates the perspective of actors and their daily working reality. We will establish the need for statutory reform by submitting excerpts on how actors' earnings are currently prejudiced through performance contracts. We will submit slides of the standard SABC, Mnet, and film contracts to support our case. We will then submit a technical summary of the rights proposed in the bill, explaining the relevance of moral rights and economic rights as articulated in the Beijing Treaty. We will demonstrate why such rights must be vested in the actor, and in addition, how these rights can and should be transferred. SAGA supports the establishment of a collective management organization for audio-visual performances, and we will submit how we envisage the CMO should fulfill its mandate. In our conclusion, we will ask that this committee revise the current Act to effect meaningful structural transformation of the audiovisual sector that will, in effect, permit actors the rights to earn a residual income based on the body of our work. The PPA, as it stands, is hopelessly deficient. In its current form, we have a piece of legislation that was drafted not only before the advent of the internet and its myriad platforms for consuming audiovisual content, but even before the advent of TV in South Africa. So the question before us today is not whether the PPA needs to be amended again. Rather, to what extent do we revise the statute? Tempting as it may be to quantify our proposed amendments into millions of rand, we urge this committee to think instead of thousands. The thousands of South African actors who, in the course of careers often spanning decades, seek only the basic statutory and contractual rights to earn a fair residual income based on the continued exploitation of their audio-visual performances. Actors do not deny the rights of broadcasters and producers to exploit the commercial value of audiovisual productions. Quite the opposite, in fact. Actors support a vibrant value chain that produces audiovisual content and that delivers it to a competitive marketplace. We have a vested interest in the commercial exploitation of our work under specific conditions, which we will detail in our submission. To put current industry practice into context, I will describe how an actor earns an income in an audiovisual production. Actors generate a primary income when they are contracted to deliver a performance in a film or TV production. So, actors would typically attend auditions and demonstrate their ability to perform the character they are asked to play. Well-known actors may attend a dozen or so auditions in a year, but of those auditions, that actor may only land 2 or 3 of those roles. This means that they would derive a primary income purely from the days they are required to deliver their performance. This is a performance fee, and actors rightly accept this reality as part of the business. However, even if this actor may have hypothetically accumulated hundreds of roles in TV or film productions, their income will only be derived from those performance fees, while the production itself will continue to be licensed and broadcast into numerous territories around the world, including on the internet, in perpetuity, with the actor's image used extensively to promote sales. It is precisely because of the deficiencies of the current Act that actors are exposed to unfair exploitation. The issue is twofold. Firstly, the Act itself has never been equipped to fulfill its intended purpose in the audiovisual age. Secondly, all an actor has, as a poor substitute for statutory regulations or collective bargaining agreements, are standard performance contracts. Let's examine then how effective are these standard performance contracts in protecting the rights of actors. The independent production sector, led by its most dominant players, has sought to embody in these contracts a set of norms and standards that determine the relationships among contracting parties. The deficiency of these contracts, however, is that they fail to reflect the interests of all major stakeholders. Let me state clearly that SAGA continues to support the need for standard performance contracts, on condition they are drafted in consultation with all industry stakeholders, which includes actors, producers, and broadcasters as a collective. We motivate for these performance contracts to be underpinned, balanced, and contextualized by a revised Performers Protection Act, amended in accordance with advances in the modern audiovisual industry and with the national constitution. It is the actor's reality that standard contracts have failed to establish and enforce an equitable balance of rights, obligations, and interests, and as a result, corporate stakeholders in the audiovisual sector continue to capitalize on their dominance at the expense of the rights of actors. Actors, as the most vulnerable contracting parties, have no option but to take it or leave it. There is no in-between, there is no negotiation, and there is no recourse. We submit examples. The SABC has its standard freelance actors agreement issued to every actor on an SABC drama, soapy, or sitcom. Adopted in 1997, this contract is now anything but standard. Various producers have now unilaterally adapted this contract to suit their own production and purposes. Let's take a look at this SABC contract. To summarize, according to the SABC's commercial exploitation clause, the broadcaster agrees to pay the principal actor a lump sum should the SABC exploit the commercial value of its production. And if the SABC fails to reach an agreement with that actor on the amount to be paid, the broadcaster will then revert to paying a pro rata share of 2% of gross profit. Easy enough. Let me state for the record, never since the adoption of this contract has the broadcaster ever entered into any negotiations or discussions to arrive at an agreed lump sum agreement or payment in respect of commercial exploitation fees. Let's move on. Slide 16. Which is the Mnet contract. Another example. This is the Mnet actors contract that demands upfront that the actor cede to the broadcaster all rights to the unlimited commercial exploitation of the actor's work in that production in perpetuity worldwide. It goes on, in all media and in any medium yet to be invented. This contract is not meant merely to secure the rights of the broadcaster. It is meant as an ironclad denial of the rights of the actor in any foreseeable future instance. This kind of contract is a complete buyout of the actor's rights to earn any form of residual income, regardless of how, when, or where Mnet wishes to exploit the production. SAGA does not refute the rights of this or any broadcaster to exercise a buyout of the actor's rights in this regard. What we challenge is the exercise of the broadcaster's buyout rights without compensation to the actor. SAGA demands that buyout contracts such as this stipulate the compensatory amount due to the actor in respect of the buyout as a separate fee distinct from the performance fee. This contract goes much further in its prejudice to actor earnings, though, in its demand that actors waive any moral right to the integrity of the actor's own profile, image, voice, and likeness. This means that Mnet reserves the right, by the signing of this contract, to edit and distort any aspect of the actor's image or their performance, even to the detriment of the actor's reputation. It is for this very reason that the Beijing Treaty has articulated the moral right vested in the actor to claim an interest in the integrity of the actor's own image and how it is used. Film. This clause assures local and international film producers that their agreement with South African actors effectively denies any claim these actors may have over their moral rights and over any residual income based on commercial exploitation of their performances. What it means is that as long as a South African actor signs this contract and delivers a performance on any film within or outside the country, actors are due only a performance fee and nothing else. While the film continues to be seen around the world, dubbed, released on DVD, seen on TV, in movie theaters, on the internet, or indeed anywhere in the universe, on any existing medium or in any medium yet to be invented, the actor has effectively signed away any right to a residual income. South African actors may share scenes as leads or as supporting leads on a feature film or a series with international actors. But the difference between them is that our foreign counterparts have a legitimate claim to their moral rights and economic rights, which allows them to generate a sustainable residual income from the commercial exploitation of their work on film. South African actors, ladies and gentlemen, honorable members, have no such right. Now, why is that? The answer is that South Africa still does not have a statutory framework that underpins the actor's moral and economic rights in audiovisual contracts. The PPAB technical summary on slide 26 describes moral rights. The Performance Protection Act needs to be amended to grant moral rights to the actor, which would include, number one, a paternity right. It is the right to be identified as the actor in that performance. The integrity right. This is the right.
Called paternity rather than maternity.
Honourable Chair, it is a I'll save my response, Honourable Chair, for later. The integrity right, to continue, is the right to object to the distortion or mutilation of the performance, especially in cases where that distortion would prejudice the reputation of the actor. Economic rights. The Beijing Treaty grants actors distinct economic rights for their performances fixed in an audiovisual medium such as motion pictures. The right of reproduction is the exclusive right to authorize the direct or indirect reproduction of a performance fixed in an audiovisual medium in any manner or form. The right of distribution is the exclusive right to authorize that the original fixation of their performance in an audiovisual medium and copies thereof can be distributed through sale and the transfer of ownership. The right of rental is the right to authorize the commercial rental to the public of the original and copies of the performance fixed in an audiovisual medium. The right of making available is the exclusive right to authorize the making available to the public by wire or wireless means of any performance fixed in an audiovisual medium in such a way that they may be accessed by anyone at a place and time individually chosen by them. This right covers, in particular, video on demand and internet-based content. The right to broadcast and communication to the public is the exclusive right to authorize the broadcasting and communication to the public of their performances fixed in an audiovisual fixation. The transfer of rights. SAGA supports South Africa's ratification of the Beijing Treaty, which makes provision for national laws to prescribe the mechanism by which the exclusive rights of authorization between contracting parties are transferred. It is therefore crucial that the PPAB is explicit in giving effect to this. It is the last level of protection for actors, the most vulnerable of whom may unknowingly relinquish all their economic rights. The PPAB guarantees that moral and economic rights are exclusively vested in the actor, and that remuneration rights are non-waivable, subject to mandatory collective management. And it is only through a contractual agreement with the producer that the actor may agree to transfer these exclusive rights in the manner prescribed by statute. Slide 29, statutory royalty sharing. The PPA was amended in 2002 to stipulate how a performer in sound recordings may share a royalty on commercial use of sound recordings with the producers of those sound recordings. In the absence of a contract between the parties, the default position is that royalties are split 50-50 between the performer and the producer. This does not apply to actors in audiovisual fixations. The dynamics of the production and commercial exploitation of audiovisual fixations is completely different. The Beijing Treaty allows for national legislation to make the distinction clear. In the case of actors in audiovisual fixations, in the absence of a contractual agreement to the contrary, the equitable remuneration due to the actor is not shared with the producer by default. The PPAB thus needs to be explicit in this regard due to a possible ambiguity introduced in the 2002 amendment regarding musicians. Collective management. There has never been a collective management organization for audiovisual performers because there have never been enabling rights supported in law. Collective rights management ensures that the actors' remuneration rights are satisfied. CMOs provide a type of legal remedy to counterbalance the automatic transfer of exclusive rights. While the creation and regulation of collecting societies is subject to the Copyright Act, it is important that the PPAB is explicit in making provision for mandatory collective rights management. Additionally, SAGA supports the establishment of a tribunal specifically mandated to arbitrate in disputes that may arise in the calculation and disbursements of residuals for audiovisual performances. This means SAGA appeals for statutory amendments that would enable a dedicated system for the accurate monitoring, tracking, and reporting of all actors' work in audiovisual media, including but not limited to TV and film. This CMO would need to be governed by a board, correctly constituted as a non-profit organization and mandated to collect and remunerate actors for the commercial exploitation of their audiovisual performances. To summarize, it is up to this committee to guarantee that the rights granted to actors in the Beijing Treaty are not diluted in the national legislation that gives effect to this treaty. Moreover, in the absence of collective bargaining rights, mandatory collective rights management is crucial. In the production and distribution of audiovisual content, the right of title passes along the value chain, so the transfer of exclusive rights is fundamental. But the transfer of rights does not imply a waiver of rights. The PPA should ensure that no actor is forced to relinquish all rights without the opportunity to negotiate. The economic value of each of the exclusive rights is independently quantifiable. This statute should ensure that each party to an agreement is fully aware of the extent of the commercial privilege being transferred along with each right. I conclude. Prior to our constitutional democracy, the economy suffered from the deeply divisive notion that the wealth of this country belonged by law and by assumption to a privileged few, while the majority were made to feel grateful to receive a pittance in exchange for a lifetime of exploitation and servitude. The economy of a participative democracy demands change to give a voice to those who contribute. Actors contribute, but nowhere in our laws is it recorded that our contributions entail a moral and economic right to fair compensation for the commercial exploitation of our work. Our submission today in support of the Performance Protection Amendment Bill is, for actors, an opportunity for transformation by granting rights and statutory protections that cannot be opposed in good conscience. We wish to motivate for the meaningful economic reform of a sector dominated by corporate monopolies that continue to oppose economic transformation. We appeal to this committee to revise our place in the economy, allow actors to work, to earn, to be seen and heard by this legislature. Allow us the right, already permitted to the many countries who consume our work, to be protected by the very constitution that we celebrate as the most progressive in the world. Thank you. We welcome your questions.